He stood in the corridor outside courtroom 4C at 4:47 on a Thursday afternoon, and the building was doing what federal buildings always do at that hour: emptying. The security desk on the ground floor had already cycled to the evening crew. The cleaning staff was working the third floor, which meant the fourth was quiet in the particular way that only government buildings get quiet. Not peaceful, but suspended, like a held breath. He had 13 minutes. The judge's chambers occupied the northeast corner of the floor, behind a door marked with a small brass plate that had been polished so many times the letters had started to soften at the edges. The door was locked. It had been locked since 2:30, when the clerk, a methodical man named Gerald, who had worked for the judge for 9 years, had sealed the outer office per the emergency protocol the judge had filed with building security 3 days earlier. The protocol was precise. No access to the chambers suite between 2:30 p.m. and close of business on Thursday. The judge had written it himself, in the careful language of a man who had spent 30 years making language do exactly what he needed it to do. He had meant it as a wall. It was in fact a door. The gentleman looked at it for a moment the way a person looks at something they've been thinking about for 6 weeks. Then he did what he had come to do, and the corridor stayed quiet, and the cameras on the fourth floor continued recording an empty hallway. And at 5:01 p.m., 1 minute past the hour he had specified in writing, he walked to the elevator and pressed the button for the ground floor. In the chambers behind him, on the surface of the judge's desk, where the sealed vault had held a single document under a standing protective order for 11 years, there was now something else entirely. The judge would find it at 5:47 when he finally believed the danger had passed. This is where it started. There are people in this country who have never been held accountable for anything, and the reason isn't that they were clever enough to avoid wrongdoing. The reason is that they were positioned close enough to the mechanisms of accountability that they could redirect those mechanisms whenever the mechanisms pointed at them. They didn't escape justice. They reassigned it. And they did it so many times, for so long, that they stopped thinking of it as a choice. It became ambient, the air they breathed. The gentleman had been watching one of those people for 6 weeks. And in that time, he had made exactly one commitment, in writing, on paper, in language that left no room for interpretation. He had kept that commitment at 5:01 p.m. on a Thursday, 1 minute after the hour he named, in a building designed specifically to prevent exactly what he had just done. The question isn't whether he should have made that promise. He didn't make it lightly. He made it because a man named Darnell Holloway had been sitting in a federal correctional facility in Cumberland, Maryland for 11 years, and the document that should have freed him had been buried under a protective order signed by a federal judge who knew what the document contained and signed the order anyway. If you've ever watched someone get away with something so large it shouldn't have been possible, and you knew, and there was nothing you could do, and you went home and had dinner, and the sun came up the next morning, and it was still true, then you already understand why the gentleman doesn't wait for permission. If this is the first story of his you're hearing, stay with it. And if you've been here before, you already know. Like what you're hearing, subscribe so you don't miss what comes next. The next move is always the one you didn't see coming. But first, he gave his word to a federal judge in writing, with no way out if things went wrong. Would you have gone through with it? The Honorable Warren T. Gideon had been a federal judge for 19 years. Before that, he had been an assistant United States attorney for 8 years. And before that, he had graduated third in his class from the University of Virginia School of Law, which he mentioned in roughly 1 in 4 conversations with anyone he hadn't known for more than 10 years. He had a photograph on his wall from 1987 in which he was shaking hands with a senator whose name now appeared on 2 courthouses and a library wing. He had another photograph, slightly larger, of himself at a charity golf tournament in Pinehurst, standing between a pharmaceutical company's general counsel and a federal appellate judge who had since been elevated to the circuit. He kept these photographs at eye level, which was not an accident. He was a man who understood positioning. Not just in the literal sense of where to stand in a room, though he understood that too, with the instinctive precision of someone who has spent decades reading who matters in any gathering and placing himself accordingly. He understood it in the larger sense, which relationships to build, which obligations to incur, which favors to call in and when, and, crucially, which information to keep close and which to make disappear. He had not arrived at the federal bench by accident. He had arrived by construction piece by piece over 30 years, and he had kept his position by understanding that the bench itself was only as secure as the information landscape around it. The Holloway matter, as he thought of it, was not something he thought about often. That was the point. He had handled it, which meant it was no longer a problem, which meant it no longer required his attention. That was the elegant function of a protective order properly deployed. It converted an active threat into an archived one, and archived threats, by definition, didn't move. They sat in a sealed vault in the anteroom of his private chambers, behind a door that required 2 forms of authentication to open, attended by a clerk who had been with him long enough to understand that certain things were part of his job that were not written in any job description. Gerald Purvis had worked for Judge Gideon since 2014. He was 53 years old, precise and quiet, in the way that institutional loyalty makes people quiet. Not because they have nothing to say, but because they have decided that what they know is not theirs to share. He managed the judge's schedule, his correspondence, and the physical security of the chamber suite. He knew about the vault. He knew about the Holloway document. He had never asked a direct question about either, because he was the kind of man who understood that the most important professional skill is knowing which questions not to ask. What Gerald did not know, what no one connected to Judge Gideon's chambers knew, was that 6 weeks earlier, a man had begun appearing in the building with the kind of consistency that doesn't announce itself. Not every day. Not on any pattern that a security log would flag, but enough to become part of the furniture, in the way that service workers become part of the furniture of any institutional building. Present, functional, unexamined. The building's maintenance contractor had a rotating crew. The crew had a supervisor who signed in at the security desk each morning. The supervisor, for the past 6 weeks, had been a man who wore the right badge, knew the right hallways, and had never once given anyone in the building a reason to look at his face. The Holloway case had come through Gideon's courtroom in 2012. Darnell Holloway was 31 years old at the time, a warehouse supervisor from Baltimore's Highlandtown neighborhood, charged with armed robbery in connection with a convenience store incident in which the store owner had been shot and seriously injured. The prosecution's case was circumstantial, but not unreasonable. Holloway had no alibi for the relevant hour. A witness placed a man matching his description near the scene, and his public defender was 26 years old and 7 months out of law school. The jury deliberated for 4 hours. What the jury did not know, what Holloway's attorney did not know, because it was never disclosed, was that the convenience store's security camera had captured footage of the incident from an angle the prosecution's evidence package characterized as non-functional. The camera had been functional. The footage existed, and the footage showed, with the uninflected clarity of a fixed lens and adequate lighting, that the man who shot the store owner was not Darnell Holloway. He was a different man entirely. Shorter, with a visible tattoo on his left forearm that Holloway did not have. The footage had been reviewed by the lead detective on the case, a man named Sorrells, who was 18 months from retirement and had a clean conviction record he was not interested in complicating. Sorrells had flagged the footage to the prosecutor's office. The prosecutor's office, facing an election year and a public that wanted results on a violent crime, had filed the footage under a category of evidence deemed inconclusive or duplicative, and had not disclosed it. This was, technically and unambiguously, a Brady violation, the suppression of exculpatory evidence, of the kind that, if discovered, would void the conviction and expose everyone who touched it. Holloway's conviction was affirmed on direct appeal. His new attorney, appointed 2 years into his sentence, filed a habeas petition that caught a break. A clerk in the prosecutor's archive misrouted a document request, and the footage came to light. The habeas petition named the footage as newly discovered evidence. The petition landed in the docket of the Southern District of Maryland and was assigned to Judge Warren T. Gideon. Gideon had known the prosecutor. Not well, but well enough. They had been at the same firm briefly in the early 90s before both moved in different directions. They had the kind of relationship that is held together not by warmth, but by shared knowledge of things that are better not discussed in open rooms. When the habeas petition arrived on his docket, Gideon reviewed the footage himself in his chambers alone. He reviewed it twice. Then he issued a protective order classifying the footage and the associated petition materials as sealed pending an ongoing judicial review of evidentiary integrity. The protective order was technically legitimate. The ongoing review it referenced was, in practice, the judge's own calculus about how long he could keep the door closed. That was 11 years ago. Darnell Holloway was now 42, housed at the Federal Correctional Institution in Cumberland, where he had been employed in the facility's library program for the past 7 years. His mother, a woman named Cheryl, who had worked as a home health aide in Baltimore for 30 years, had retired from that work not because she wanted to, but because her knees had given out, and she spent her Tuesdays driving a 2007 Honda Accord 3 hours round trip to sit across a table from her son and tell him what was happening in the neighborhood, which was mostly the same things that had always been happening, which was not much. The gentleman had found the footage through a chain of inquiry that began with a legal aid organization in Baltimore and ended with a sealed court document that was not supposed to be accessible to anyone without a specific set of credentials. It is not worth explaining how he came to have those credentials. What matters is that he reviewed the same footage Gideon had reviewed in 2013, alone, in a different room, and arrived at the same conclusion by a different path. The man in the footage was not Darnell Holloway, and the document that proved it was sitting in a vault behind a door in a federal building, and a judge who knew this had been leaving it there for 11 years. He did not feel anger when he arrived at this conclusion. That is worth understanding about him because people tend to assume that a man who does what he does must be running on something hot. He wasn't. He was running on something much colder and more durable than anger. The specific clarity that comes from seeing a situation exactly as it is, without the distortion of outrage or the softening of hope. The situation was as follows. A man was in prison for something he did not do. The evidence of his innocence was sealed behind a protective order issued by the person who should have freed him. That person had been doing this, not just this, but the general category of this for 19 years. And he had done it without consequence because the systems designed to produce consequence had been arranged through patience and positioning to look elsewhere. The gentleman looked at this situation for a long time. Then he sat down and wrote a note. It took him 4 drafts. The final version was 14 words. He wrote it in a hand that was legible but not distinctive, on paper that was not traceable, and he placed it between 2 case files in a locked briefcase that belonged to Judge Gideon, in a manner that is not the subject of this story. The note read, "By Thursday at 5 p.m., the document that should never have disappeared from the Holloway record will no longer be exclusively yours. You have my word." He did not sign it. He didn't need to. Gideon found the note on a Sunday morning in his home study, where he always reviewed his docket before the week started. He sat with it for a long time. He read it 3 times. Then he set it on the desk and looked at the wall for a while, at the photograph from Pinehurst, at the photograph from 1987, at the framed copy of his law school diploma that had hung in the same position in every office he'd ever occupied. He picked up the note again and read it a 4th time. Then he called his clerk. Gerald arrived at the study within the hour. He read the note without expression. He set it back on the desk. He asked, in the careful way he asked everything, whether the judge would like him to contact building security. The judge said yes. He also said he would like the vault's access log reviewed and the chamber suite's security protocol upgraded before Monday morning. Gerald said he would handle it. Then the judge said, without looking at Gerald directly, that he would like the item currently in the vault moved to a secondary location before Tuesday. Gerald understood what that meant. He said he would handle that as well. The gentleman had anticipated both of these responses. He had, in fact, been counting on them. Here is the thing about people who have spent their professional lives managing information. They tend to believe that the management of information is itself security. That if you move something from one sealed container to another sealed container, and the second container is less known than the first, you have solved the problem. What they don't account for is that the act of moving the thing, the logistics of it, the specific human decisions required to execute it, the narrow window in which it has to happen, creates a different kind of exposure. Not a vulnerability in the vault, a vulnerability in the motion. Gerald Purvis drove a gray 2021 Subaru Forester. He lived in Silver Spring. He kept a predictable schedule, which is to say that a person who had been watching the building for 6 weeks would have a very clear picture of when he arrived, when he left, which entrance he used, and what his route looked like on the specific days when he carried something with him that was not his usual briefcase. Gerald was careful in the way that loyal institutional men are careful. He never discussed his employer's business, he never varied his public behavior, and he never drew attention to himself in any way that could be described. What he did not do, because no one had ever given him reason to do it, was account for the possibility that someone who already knew about the document was also watching the logistics of its movement. The secondary location Gideon had chosen was not in the federal building. It was a private archive facility in Chevy Chase, the kind of place used by law firms, estate attorneys, and people with the specific profile of someone who needs long-term storage of sensitive documents with a minimum of institutional oversight. The facility had good security. It was not part of any government system. No one looking at its client list would find anything remarkable. This was, from Gideon's perspective, the cleanest possible solution. Move the document out of the federal building into a private facility under a storage agreement filed in a name that did not connect to him directly. Problem solved. The gentleman had identified the facility on Monday when Gerald made the inquiry call from a landline in the outer office with the door slightly ajar. Now, consider what the judge had done in the 4 days between Sunday morning and Thursday at 2:30. He had contacted building security. He had requested an emergency access restriction on his chambers suite. He had arranged for his most sensitive piece of evidence to be transferred out of the federal building to a private location. He had, in other words, removed every layer of institutional protection that had surrounded the document for 11 years and replaced it with a single transfer, a brief window of physical motion in which the document existed somewhere between where it had been and where it was going. The stronger he built the walls, the cleaner the gap he created between them. The emergency protocol Gideon filed with building security on Monday morning was specific. No access to the chamber suite between 2:30 p.m. and close of business on Thursday. It was designed to create a protected window for Gerald's return to the office after completing the transfer. What it also did was ensure that between 2:30 and 5 combined, there was no authorized personnel in the suite to observe anything, and that any maintenance work that had been scheduled for the chambers corridor would be rerouted per protocol to avoid the restricted zone, except for essential services. Essential services had their own access category. Essential services had been pre-cleared by the building manager at the start of the week, before the emergency protocol was filed, in a scheduling conversation that had happened the previous Wednesday. The gentleman stood in the corridor outside courtroom 4C at 4:47 p.m. on Thursday, and the building was doing what federal buildings always do at that hour. He had 13 minutes. He did not hurry. Hurrying is for people who haven't thought it through. He moved at the pace of someone who belongs in the hallway, which is to say, at the pace of someone doing a job, finishing it, and preparing to log out for the day. He had been in that building, on that floor, enough times in the past 6 weeks that the motion of it was in his body. He knew which tile squeaked at the turn in the corridor. He knew that the 4th floor men's room door had a hinge that needed oil and would announce itself from 15 feet away if not opened with a specific pressure. He knew that the camera at the far end of the hallway had a blind spot of approximately 4 feet at its leftmost edge, and that this blind spot aligned with the specific stretch of wall beside the chamber suite door in a way that was not visible from the security desk's monitor bank, but was legible to anyone who had looked at the camera housing carefully enough to understand its field. He was inside the suite at 4:51. What happened between 4:51 and 5:01 is not something that will be explained here. Not because there is nothing to explain, but because the explanation is not the story. The story is what the judge found when he arrived at his chambers at 5:47, still in the suit he had worn to a reception at the Federal Bar Association that afternoon, still holding the small glass of sparkling water he had carried from the reception room, before deciding he needed to check the vault one more time before he could sleep. The vault was intact. The biometric reader showed no anomalous entry. The outer door showed no signs of tampering. Gerald's access log from the morning showed exactly what it was supposed to show. Every layer of security the judge had reinforced since Sunday was exactly as he had left it. The surface of his desk was not. On the desk, in the center, where the document should not have been, could not have been, according to every system the judge had spent the week constructing, was a laminated copy of a court order. Specifically, the wrongful conviction order in the case of United States v. Darnell Holloway, signed by the Honorable Warren T. Gideon in 2012. The lamination was clean and professional, the kind used for documents meant to last. The document was open to the page containing the judge's certification that all relevant evidence had been reviewed, and that the conviction was supported by the preponderance of the record. One line was underlined in red. The sentence that read, "Having reviewed the totality of the evidentiary record, this court certifies that no material exculpatory evidence has been withheld or suppressed." The judge stood at his desk for a long time. He did not sit down. He held the glass of sparkling water and he looked at the document, and the building continued to do what buildings do after hours. It breathed, it settled, it made the small sounds of systems running in the absence of people. He understood what it meant. Not just that someone had been in his chambers. That was alarming enough. Would have been alarming enough on its own. But what had been left? Why that sentence? Why that underline? The document was not evidence of the Holloway footage's location. It was evidence of something else. Something that couldn't be prosecuted, couldn't be sealed, couldn't be reclassified under any protective order ever filed. It was evidence of what he had known, and what he had certified anyway, and what he had been certifying, in one form or another, for 19 years. He set the glass down. He looked at the photograph from Pinehurst. He looked at the photograph from 1987. Then he looked back at the document on his desk, at his own signature, at the underlined sentence, and something moved through his face that was not quite any of the emotions people usually name. It was more like recognition. The specific compound feeling of a man who has spent a long time arranging for a particular truth to stay in a room he controlled, and who has just understood that the room no longer belongs to him. He could not call the police. What would he report? An unauthorized entry that the security systems showed hadn't happened? A document that had appeared on his desk that was, technically, a copy of a public court record? He could not involve building security without answering questions about why the document's presence disturbed him specifically. He could not call the prosecutor who had buried the footage without reopening a conversation that had been closed by mutual agreement for more than a decade. He could not tell Gerald because what Gerald didn't know was a form of protection, and that protection had now become Gideon's primary remaining asset. He stood at his desk, and he understood that the promise in the note had been kept, and that keeping it had been the point. Not what it accomplished logistically, but what it meant. Someone had made him a commitment in writing, with his name on it, 11 days in advance, and that person had honored it, at the precise hour specified, against every defense Gideon had constructed. With the kind of precision that is not performance, it is proof. Proof that the person who made the promise had the capability to keep it from the moment they wrote it down, and that the promise itself was the least interesting part of what they were able to do. The gentleman was not in the building when the judge found the document. He had been out of the building for 47 minutes. He was, at that hour, in a coffee shop 4 blocks north of the federal courthouse, at a corner table near the window, with a cup of coffee he hadn't touched yet. He was reading something, not about Gideon, not about the case. He had already read everything about the case that he needed to read. He was reading something else entirely, with the specific quality of attention of a person whose work is done and who has given themselves permission to be elsewhere in their mind. He had made one stop before the coffee shop. It was not a long stop, and it did not require him to enter any building. It required only that he leave something in a particular location, the mail slot of a particular law office on Calvert Street in Baltimore, operated by an attorney named Priya Anand, who had been working for the past 3 years on habeas corpus petitions for inmates at federal facilities in Maryland. He had left a sealed envelope. The envelope contained no note and no explanation. It contained a clean copy of the security camera footage from the convenience store in Highlandtown, captured from a system that had been in use in 2011, showing the incident in question from the relevant angle, with a timestamp that was consistent with the arrest record for Darnell Holloway. The copy was not the copy from Gideon's vault. The question of where this copy originated is not one that will be answered here. What will be said is this. Priya Anand arrived at her office the following morning on a Friday and found the envelope in her mail slot and opened it at her desk with the methodical attention she gave everything, and watched the footage twice before she put it down. Then she sat still for a moment in the way that lawyers sit still when something shifts in a case they thought was immovable. Then she called a paralegal named Marcus, who had been working the Holloway file as part of a clinic project, and told him to clear his afternoon. The Holloway case was not resolved the next week. That is not how these things work. Legal systems move slowly, even when the evidence is clear, especially when the evidence surfaces in ways that require explanation. And Priya Anand was careful, meticulous, and experienced enough to understand that the first thing she needed to do was establish the provenance of the footage in a way that a court could work with. That process took months. It required the kind of persistent, patient legal work that doesn't look dramatic and isn't designed to. It required filings and motions and responses and the specific endurance of someone who does this because they believe the work matters, which Priya Anand did, with the clear-eyed commitment of a person who learned early that the law is only as good as the people willing to push it in the right direction. The gentleman followed the case from a distance, the way he followed all of them afterward, not closely. He was not someone who needed to see the ending to know how it felt. He had known, from the moment he understood what was in that vault, that the work was worth doing. The ending was not his to manage. It belonged to the attorneys and the courts, and eventually to Darnell Holloway, who would one Tuesday receive news of a different kind than his mother had brought him across that table for the past 11 years. What the gentleman sat with in the weeks after was something quieter than satisfaction. He had made a commitment. He had kept it. He had kept it at a specific time, to a specific standard, against conditions that were designed to make keeping it impossible. And he had kept it not for the drama of the keeping, but because of what a kept promise means. Not rhetorically. Actually, a promise made in writing without room for interpretation to a person who had spent his career understanding that language can be made to mean whatever you need it to mean. That promise is a statement about what kind of person is making it. It is a statement that cannot be walked back, and honoring it at the exact hour named against every defense constructed to prevent it, that is not a performance of integrity. It is integrity. The difference matters, and it is one the judge understood when he stood at his desk and looked at his own signature. There is a kind of person. The gentleman had thought about this in the hours after, sitting at the corner table with the untouched coffee, who makes promises they intend to keep only if the circumstances remain favorable. They mean it when they say it. They just mean something slightly conditional. And then the circumstances shift, and the cost becomes real, and they discover that the meaning they attached to the words was always contingent on the absence of that cost. This is not dishonesty exactly. It is something more like imprecision, a failure to understand at the moment of commitment what commitment actually is. He had understood it, going in, completely. The note had been written knowing what would happen in the 11 days between the Sunday morning the judge found it in his briefcase and the Thursday at 5 p.m. he had specified. He had known that every defense the judge built would create the conditions the plan required, and he had also known that if something unexpected changed those conditions, if the move the judge made was something genuinely unpredictable, something that closed the gap before Thursday, he would still have to keep the promise at 5 p.m. on Thursday, exactly as stated. because the promise was the statement, and the keeping of it was the proof, and both of those things had to be true, or neither of them were. He had been prepared for that version of Thursday. He had his contingencies, and his contingencies had contingencies, and none of them were comfortable. The version that actually happened was not the hardest one, but it required everything he had. And there were moments in the building, in the corridor, in the specific silence of an empty hallway on a federal floor at 4:51 p.m., where the weight of the commitment was present in his chest in a way that had nothing to do with fear and everything to do with understanding. He had said he would be here. He was here. That was the entire point. He thought sometimes about Cheryl Holloway making that drive on Tuesdays. 3 hours, round trip, in a 2007 Accord, with the kind of suspension that announces every imperfection in the road. He didn't know her and had no intention of knowing her. She was not his secondary character. She was the reason the story had a shape at all. She had been driving that route for 11 years. She'd been doing it because she was the kind of person who shows up for the people she loves, without calculation, without a plan, without any expectation that it would resolve the way she wanted it to resolve. She just kept going, every Tuesday, and that, the gentleman thought, was its own form of commitment, not strategic, not theatrical, not announced to anyone, just the raw insistence of a person who had decided that showing up was what she was going to do, regardless of what it cost, and who had never once required the logic of it to be explained. He thought about the difference between that kind of commitment and the kind that requires an audience, the kind that gets framed and hung on walls, the kind that comes with photographs and plaques and speaking engagements, where the commitment is announced so that its announcement becomes the thing, not the action, not the cost, not the continued showing up even when showing up is all you have left. He had spent years watching that version of commitment performed by people who had carefully arranged for the performance to be confused with the substance. And he had spent the same years watching the other kind operate quietly, in cars with bad suspension on long highways, in law offices that closed late, in legal aid clinics where a paralegal named Marcus was still at his desk at 8 p.m. on a Friday because a case had shifted and the work needed to be done. The judge had kept his wall. The gentleman had kept his word. Only one of those things mattered, and only one of them was true in the way that truth holds up under pressure. He finished the coffee eventually. He left a tip that was slightly more than the bill. He walked outside into the October air of a city that didn't know what had happened in it that afternoon and wouldn't. And he thought about the next thing he needed to think about, which was something else entirely. And the afternoon kept going the way afternoons do, and the building 4 blocks south held its breath. And the judge stood at his desk in the particular silence of a man who has just understood that the language he has relied on his entire professional life can be used by someone else, against him, with his own signature already on it. Now, if you're still here, and if you made it to this moment, you were here for all of it, then you understand what this episode was about. And it wasn't about a federal building, and it wasn't about a vault, and it wasn't about a judge who built the wrong wall. It was about what it means to say something and then be the kind of person who means it when it costs something. The gentleman made a 14-word commitment to one of the most protected men in his professional world, and he kept it. Not because keeping it was easy, because he had said he would. There are stories on this channel about intelligence and misdirection and the elegant collapse of arrogant systems. And those things are here too. But underneath all of it, in every episode, in every move the gentleman makes, is the same foundation. The code doesn't bend when the conditions get difficult. That's not when the code is tested. That's when you find out whether you had one to begin with. If this story landed with you, if you recognize the difference between a promise and a contingent statement that sounds like one, leave a like. Subscribe if you want to know what comes next, because the next one is already in motion, and it starts with a different kind of notice, sent to a different kind of person in a way they will not see coming, until it's too late to matter. And before you go, have you ever honored a commitment that everyone around you said was impossible, and found out, in the keeping of it, that it was the only thing that mattered? That's not a rhetorical question. Think about it. The answer tells you something about the kind of person you're building yourself to be. The gentleman already knew his answer. He knew it on Sunday when he wrote the note. He knew it every day between Sunday and Thursday. And he knew it at 5:01 p.m., standing at the elevator, waiting for the doors to open in a building that had done everything it could to make sure he wasn't there. He had his answer. The question is whether you have yours.